right, everyone. The last session of the day, we've got another one going on another track, but the last session of 2 great days. Before we close up, I want to say thank you so much to InfoCast for everything you've done. Elliot's been in here with us passing the microphone around. I just think you guys have really done a great job running this whole symposium. It's been great, and thanks to the hotel and thanks to all the employees. The food's been great. Thank you to Bia for all your work on this and helping to organize and choose speakers. It really has been a lot of fun. So we have an hour and a half to go. We've got a great panel here. This panel is talking about, where are we going? Kind of ending. We've been talking about everything that's been going on, where we've been, how we've done everything. But now we're going to start talking about, we'll go over a little bit of that also, but we'll talk about what's coming up next. So first I'm going to let the panel members introduce themselves and tell us a little bit about yourself.
Hi, my name is Dominica Mendiola. I am one of the deputy directors for the Department of Revenue's Marijuana Enforcement Division, focusing on areas of legislation, policy, and business licensing.
Good afternoon. My name is Eugene Hillsman. I'm the deputy director of the San Francisco Office of Cannabis.
Good afternoon, and my name is Marley Bordowski. I'm the Director of Prosecution for the Denver City Attorney's Office. I've worked with Ashley and her team since 2014 when we started this adventure, and we've just continued on with the adventure, and now I have my own marijuana team within the Denver City Attorney's Office. It actually takes a team of us to deal with this, so that's what we've got.
Hey, I'm Brandon Goldner, and I supervise the City of Portland's cannabis program. I've been with them since 2015, which seems wild to say, and I've been supervising for 2 years.
Yeah, and Brandon and I were just speaking. Brandon's been to every one of these symposiums. You were with us from the very beginning. So I think it's been said a number of times by a bunch of different people up here that this is an industry that is quickly evolving. They're entrepreneurial, they're risk takers, there's a lot going on. I've heard people say build the plane while they're flying it, or the fire truck on the way to the fire, or something like that. So that's continuing to go on. We keep seeing that continue to go on, and we continue to have lots of things to talk about at these symposiums. So thinking about that, maybe what we thought we'd start with is the question of, let's just start with, how have you kept pace in the past? Because even just when legalization first started, Brandon, how did you in Portland, how did you do it? How did you keep pace with what was going on?
Yeah, I have a couple thoughts on that, and I think the first is to have an expectation that things are gonna change and that you're not gonna get it right the first time. As regulators and staff and supervisors and even elected officials, if you're able to set that tone early, it makes it a lot easier to then pivot later to say we're going to be crafting these regulations with our best understanding and that they might change, so people know that. And also just, I think some measure of humbleness and willingness to say when you got something wrong is important. To be human in all of this, I think, has also been super important for me and for our team. Explaining the logic behind the policies, actually, Tina Axelrod mentioned in the previous panel on zoning and building codes that if you're able to explain the logic behind those policies, it makes your work a lot easier and, again, allows you to pivot faster. And then 2 more quick things. One may seem obvious, but like listening to your applicants and to your licensees and to the industry, hearing what they're saying, seeking out and scoping out if you hear a concern, particularly if it's recurring, to take it seriously and do your due diligence to make sure that you're paying attention to that, because that can flag things that you may not otherwise know until a lot later, so that's important. And then the last thing, and this is just my experience being a relatively new supervisor, encouraging your staff to not only execute the rules, but to help you as a thought partner, I think is really, really important. And encouraging that culture of exploring things and asking questions. And maybe you're going to get the same question several different times about a particular policy or regulation, and being able to explain why. And as a regulator speaking with industry in that way, you might not always agree, and that's okay. But yeah, I think that having lots of different thought partners in this work makes changing and evolving a lot easier, and it allows you to keep pace a lot easier.
Great. And why don't we just go right down the line? Marley, if you can talk to us about how in Denver you've managed to keep pace.
Absolutely. I would have to echo a lot of the things that Brandon said. I know that this is the second day in the last session of the conference, but you've heard the word collaborative model throughout that, and it's absolutely true under Ashley's leadership. It's the only way we've been able to regulate this effectively. I'm pretty proud of the model that Denver has. I've talked to several of you throughout the last couple of days, and I know that you're not as lucky with the agencies you have to be able to collaborate the way Denver has. But if you can get that, some form of a collaborative model in place in your city, I think that is the number one thing that's made Denver successful. I have an example of that just from yesterday. I was called out right before one of the sessions for a hemp grow that fire had found, and things were escalating quickly, and they needed legal guidance on scene right then. The fire department responded, DPD responded, I responded. The public health department is now involved because they're extracting from these nasty plants. It was horrible, and we had to actually red tag the building, and all during this conference. But all of those agencies responded like that and are working at it from their realms of authority. So that's a perfect example just happening now that Denver does. I would also say that one of the things Ashley implemented and that I probably pushed back as a career prosecutor at first, but now I see the value of it, is reaching out to the industry, having industry check-ins, learning from the industry is really important. There's so much we didn't know, still don't know. And just having those relationships with the industry has been critical for Denver. And then also some internal meetings. Okay, this is what the problem is. This is what our boots on the ground have identified. What are we going to do? What's the right approach to it, number one? What's the right approach to it from a public health, public safety perspective? But also what's the right approach from a policy perspective? So those are constant meetings, and it seems like a lot of meetings sometimes, but for us, it's just been critical to keep that communication open. Maybe you don't need to do it through meetings, but communication's critical.
No, Marley loves all the meetings that we have.
Meetings, my favorite.
You do. You have fun.
So those are the big things that have helped Denver.
Great. Eugene?
Sure. Thanks for having me. One of the things that we've done is essentially built in legislative change into our permitting process. So I know the nomenclature here at this conference is to describe waves of states that have legalized and describing it as 1.0, 2.0, 3.0. In San Francisco, one of the things that we've done is essentially each year we anticipate having a legislative process that encourages people to come forward with legislative changes, cleanup, and we call those versions 1.0, 2.0, 3.0. So right now, in this fall, we're preparing for our next substantive set of changes to the legislation. So that's one. The expectation is that we have not gotten the legislation right in places in which we haven't. We're open to hearing feedback, and we'll take in the consideration from industry, supervisors, other individuals who are really interested in cannabis in the city and county of San Francisco, and incorporate those changes legislatively. So that's kind of the big way that we've been able to kind of adapt and be particularly nimble, is because our Board of Supervisors has been open to that legislative process. So that's number one. The second is really around our ability to rule make. So in thinking about places in which we have not been particularly clear, we've taken the opportunity to issue rulemaking on our website. We have a public comment period, so people can essentially review the kind of places in which we've made clarifications to essentially describe additional changes that we've made in the ordinance, so that we can be particularly pointed about how we're interpreting the legislation. And so we're communicating that to the general public, and if we've got something wrong, they have the opportunity to communicate that to us. In some cases, we've taken the feedback and said, you know, that's a ridiculous idea. We would never incorporate it in the legislation or our rulemaking. But in other instances, we've really found that to be a useful channel to provide us with things that we wouldn't have necessarily thought of. So we've been able to take those changes and then incorporate them into our rulemaking. And as was said before, one of the things that's really been important, and I would encourage everyone to figure out how to do it effectively, is to develop relationships with the industry. One of the things that we've done is actually host listening sessions where the industry can come into City Hall. We're on actually our 4th one this year, in which they can just describe to us challenges that they're facing. We can have a really open and frank conversation about ways that we can improve our permitting process. And thinking about things like efficiency, we've had a lot of kind of complications because of our existing industry. So the city and county of San Francisco has had a regulated medical cannabis dispensary industry since 2005. So there are a lot of stakeholders who are used to engaging with the city, and so managing those expectations can sometimes be challenging. But it's really been a priority for us to figure out constructive ways that we can engage them, either through email, by having open office hours, and also these listening sessions that I just described. I'll also note that time that you're spending with the industry is not without a cost, right? Because you have limited time and resources. And it was a decision that our office made to really be open to make sure that people had that good relationship with our office.
Dominique?
So a lot of the initiatives that my colleagues here spoke to are also items that our division has been focused on. There is a need to understand, collectively acknowledge that our regulations are not going to contemplate every scenario, and that we need to be open to adapting as we continue to learn. And that goes to how critical it is to engage with licensees, our industry members, and understand what developments are occurring in the industry, as well as our local partners. With Colorado being a dual licensing system, we need to ensure that we're working closely with our local partners. Approaches to rulemaking have developed over time. An example would be our historically meetings when we are presenting and discussing draft rules have been a more formal process, where we have identified stakeholders that will serve around a panel table, and those are the individuals who are contributing to the discussions. There is an opportunity for public comment, but what we've been doing this year is looking at different formats that really enhance that collaboration. We have brought in a facilitator on occasion so that we can engage more in the details of the discussions and focus on that. We've had small group discussions, breakout sessions, where we really focus on specific areas of rulemaking as we are implementing different legislation around hospitality establishments that would allow for consumption on site, a delivery permit that will be issuing beginning in January, a number of changes where we need to be open to various ways of engaging. And that goes beyond just the rulemaking session. It's that proactive engagement that occurs in between, where we can understand and ideally get ahead of some issues as we work with stakeholders. We need to be dynamic and understand that we can shift quickly and accept the need to shift quickly. And acknowledge that we are all navigating changes together. We have a lot of staff who are wrapping their arms, including leadership, around significant changes in the law that we're charged with implementing very quickly. As we understand or identify issues and work through those issues, we have to keep in mind that licensees are going through the exact same process. So as issues come up, it's ensuring that we're working together and navigating those issues together.
So Dominique, I love what you just sort of said at the end. That's one thing, we as regulators say, well, it's changing quickly, they're innovating, and we might get it wrong, and we have to be nimble, and we need to be able to change. But like Dominique just kind of mentioned, can you explain to us some of the feedback that you might get from the industry about, we're like, well, we got it wrong, that's because you're changing, but what about the costs that they incur when we get something wrong and have to pivot?
Well, one thing that we've done, and this was mentioned earlier, is the drafting process as we're developing rules is in those discussions, rather than us in every working group going into those meetings having drafted proposed rules that other people around the table are reacting to. We want to have that be a more collaborative process where if somebody's identifying an issue or says this isn't going to work, then the next question will be, well, tell us how it's going to work. Draft that language, and we will sometimes say we want to see your digits, because that will oftentimes be what we can just incorporate and become the rule itself, so that we can ensure that we're thinking about what those costs might be. And when we have that hands-on process that involve those who are going to be subject to those regulations, drafting those rules, then I think it helps ensure that we are taking that impact into account.
And today you guys heard Louis Koski talk about the labeling issues, and when we change labeling rules, I think the state's been really generous to the industry about giving them time to ramp up. Could you talk a little bit about that?
Yes, so we had, even outside, as we were leading up to our formal rulemaking, we saw an opportunity to hold a series of just informal focus groups where we brought industry members together, wanted to understand the different types of packaging that was developed that they're using, so that we can understand some of the challenges that they may be facing with smaller packages, or what we have identified as the nesting doll scenario, packages within packages, and then you have the required label and child-resistant quality on the outermost package, and you're left with that innermost package that's actually holding the product that doesn't have the child-resistant quality and that has no labels on it. So when we obtain more information around those issues, we brought people together, looked at different ways that we could resolve that, and examples, we're working with our partners in other states, having warning statements up on a screen, and identifying how we could align with language of other states for those operators who are working in other states, and simplifying language. So we've made a number of changes over time with an interest in streamlining our regulations. One of the other issues that we've identified that has required some developments in our regulations have been around the different types of products that we see on the market, where our regulations originally drafted contemplated 3 different categories of essentially the flour, and then you have product and concentrate. But as we saw the development of new types of products on the market, we developed our packaging and labeling requirements based on an intended use model. So keeping in mind really what the intended use is of the product to inform those now testing as well, testing, packaging, and labeling requirements.
So kind of staying on this topic of us having to change our regulations, I mean, after all, our job, I believe, as regulators is protecting public health, safety, and welfare. So sometimes we're going to have to pivot, and it is going to cause the industry to incur additional costs. And they've chosen to be in a risky business that's evolving quickly. Has anyone had to strike that balance and gotten feedback that you'd like to share along those lines?
Not necessarily around public health and safety, but I'll share an anecdote in which we did have to be pretty reflective about the processes that we had instituted and figuring out a way to communicate more clearly to some of our operators. One of the things that you may know about San Francisco is that it can sometimes be a peculiar place to do business. And so one of the things that we didn't anticipate in really forming our ordinance was around the volume of interest with regard, particularly for storefront retail applications. So because of the buffer requirements, we needed to figure out a way to communicate that information very clearly about what were the viable locations in the city and county of San Francisco, right? So in order to do that, sometimes people were literally purchasing buildings, right, in a place where the real estate is very expensive, or signing leases that were locking them into long-term deals. And if they could not rely on the information that we were providing them, then they could incur significant costs. So we had to essentially kind of recalculate, reinstitute some of our processes to make sure the information that we were delivering to our operators, who were literally taking the plunge in some cases, to make sure that the information that they needed was as accurate as possible, because they were making significant determinations about how to move forward using that information. So we essentially had to think about our existing process, essentially communicate more effectively with our planning department who are making determinations, and then figure out a way to communicate that accurate information both to the general public through a planning map
Right.
where people could look visually and see what were the existing locations or places in which we had pending applications, and then also communicate that information directly to the applicant. So we were not as communicative early, but we essentially reevaluated our process to make sure we were delivering that information in a timely fashion.
Great. So, and kind of continuing on that path of sort of in the past, where have you had to course correct? Marley and Brandon, do you have any does anything pop to mind where?
I have so many stories I could tell you guys, but I have a couple stories I want to tell that go to Ashley's question. One early on in our 2014, 2015, and one that just happened this year. One involves zoning. So when the license types were created in 2013 and into 2014, when we actually went online with commercial businesses, everyone thought that the MIPS that you've heard about, the infused product manufacturers, were essentially like a bakery, right? They're making brownies, they're making baked goods. And so the zoning decision was made to put them into the zone districts in Denver that allowed industrial kitchens, because they're a bakery. Well, we soon quickly found that they were doing a lot more than just baking brownies. They were doing extractions with some highly flammable solvents and storing those solvents on site. Some of them, that's all they were doing, and they were massive extraction facilities. Don't belong in commercial kitchen districts. So we had to do a lot of stakeholder groups, going out on field trips to say, okay, what are you doing out here? What's a better place for you to be located in the city rather than right next to a residential zone district? And ultimately, we did some pivots on our zoning code to put some of these folks into heavy industrial zone districts. So that was one that happened early on. The one that happened recently came about with regard to hemp, which is kind of the emerging issue for all of us, I think, trying to get our arms around that. We're running into more hemp in places like yesterday, but also we're seeing some types of hemp in our airport. Recently, we had a box full of hemp seeds come through the TSA checkpoint. Well, they're seeds. The person claimed they were seeds, but on the label it said that they're going to grow up into, when they become an adult, into 30% THC concentration. So clearly someday they're not going to be hemp, but what are they right now? And so we did a lot of research, went back and read that damn farm bill inside and out, and ultimately we had to give the seeds back, because the way that hemp is defined in the farm bill is the seeds of the cannabis plant with the THC concentration of 0.3% or less. Well, seeds don't have any THC in them. They're going to grow up to have THC in them. But right at that moment, they're hemp. And so we had to give them back. So that's just a kind of a pivoting in how are we going to react to it with DPD out at the airport, and how are we going to handle those situations. So those are a couple stories.
Well, Portland got everything right the first time, so I don't. No, I'm kidding. The anecdote I wanted to share has to do with just being imaginative about how your regulatory framework might put stresses on other offices that have regulations. So our office may be like many of yours or those being developed, where some of our regulations our staff enforce and some of them other offices enforce. And one of the regulations we had early in 2015 was that every license type had to have total and complete building permitting before they could get a license with us. In Portland, there were some unique factors that made that requirement tough to meet. Our permitting department is a revenue generation department that had been hit by the recession years before, and their layoffs hadn't fully gone back up to the service levels that they were before the recession. Plus, there was like an unprecedented amount of construction in Portland at the time. You add that on to, here come many hundreds of brand new businesses all trying to get this requirement at the same time. And you had a deadline from the state of the beginning of 2017 where retailers were going to come on board. I'll spare some details. Suffice to say that if our program's permitting requirement for retails, if we had stuck to that, we would have had many, many dozens of retailers who would not have been able to open, would have been at a competitive disadvantage, but not for that requirement, they otherwise would have met all state and all other local requirements. So We changed that not because we don't care about building permitting for retailers. Of course we do. It was just a reflection of the system was being stressed by this new industry coming on at the same time. So just be really imaginative about, okay, if we have X, Y, and Z requirements, and we're going to need, these things from certain offices, coordinate with them. How long is it going to take? It sounds obvious, and it's something that we should have seen, and we missed it, so we had to pivot.
So Dominique and Eugene, do you have any other examples of time when you've had to pivot, or you were surprised, or did you already cover that?
I can give an example?
Yeah, for sure.
All right. There was an example with hemp, and that reminded me of something I could share. So last year, we navigated an issue around testing of hemp. What we identified is statutory language that allowed for testing of hemp using testing facilities that the Department of Revenue's Marijuana Enforcement Division licenses. What we had learned over time, though, is that based on the statutory language and looking at the legislative history, really contemplating that allowance applied to the plant material, and this also touches on the fact that there are different agencies involved in implementation of cannabis laws around the state. There are hemp registrants. So if we're talking about the cultivation of hemp, those are registered by the Department of Agriculture. And so the law allowed for those registrants to submit samples of hemp to testing facilities that we license for purposes of testing. But when we identified that hemp-derived products were also being submitted to testing facilities for such testing, we, following investigation and communication with testing facilities, communicated that we did not believe what we saw occurring was permitted under the statutory language. We held a number of working groups. We brought marijuana industry members, hemp industry members together, along with, and it required coordination with the Department of Agriculture and Department of Public Health and Environment, with DOR, to identify a way to approach this such that we were keeping public health and safety at the forefront. And what we identified here was that what hemp registrants and manufacturers of hemp-derived products were really trying to do is, for purposes of submitting samples for testing, is obtain information that we identified really goes to public health and safety. So we worked together and developed and issued an industry bulletin that provided some policy guidance around that, with an expectation that we were going to continue to work together with stakeholders in developing a statutory fix to what we identified as that problem. And it also touched on our ability to approach things in a risk-based manner. Where are we going to focus our enforcement resources? If we can establish some appropriate safeguards around how those samples are being submitted to testing facilities that we license, and can track that information, then we got to a place that we were comfortable approaching this with stakeholders in a way that we could say, we're looking to work with you to get a statutory solution to this, and here is some guidance in the meantime.
Great. So Eugene, what's next on the horizon in San Francisco? How are you going to do it with everything else you have to do, and how can you apply some of the lessons you've learned from having to pivot in the past?
Sure. So one of the things that I'll say has kind of drawn a lot of our attention in thinking about what the next wave of legislation might be is designed to provide more support to our equity applicants, right? Both around identifying what are existing barriers, and then to figure out how leveraging existing city resources might be able to better serve them, right? So we are a kind of a first in, last out permitting system in San Francisco. So you start the process with us and you end the process with us. But in between, depending on the type of activity that you're looking to start your cannabis business with, you might need to engage with the Department of Public Health. You might need to engage with the Mayor's Office of Disability, our building inspectors, fire, plumbing, electrical, you name it. If you want to do consumption, then you would be required to engage with our Department of Public Health. So there are a lot of reasons why you might need to engage with the City and County of San Francisco. And even though we have fee waivers and priority processing for our equity applicants, and those are the only applications that we're processing currently, we started to try to figure out how we can develop better relationships with our partners to make sure that when we send them off to get their architectural plans and they're reviewing them with police officers who are looking at their security premise and their plans, that they know that these people are being given special attention, right? And so we've been faced with some pushback, right? Because they're like, look, the Office of Cannabis can treat you however they want to, but when you come to us, you're just like everyone else. And so one of the things that we've had to be strategic about is really bringing those folks into our office, having communication from other stakeholders in City Hall to communicate that this is a city priority, right? And so that's a space in which we've been pretty deliberate about figuring out how to formalize those processes. So now, for example, if you want to do a plan review with the Department of Public Health, if you're an equity applicant, the first hour of that is waived, right? But it took a lot of conversation and communication for us to kind of get those types of outcomes because there was nothing organic or automatic about it. So that's a place in which we spend a lot of time thinking about what is the next level of support that we can provide to people who are coming through our permitting system. So currently San Francisco already has delivery, right? So we have 41 operators, both some of our legacy operators and our temporary permittees. So one of the things that we're focusing on now is to really figure out what our enforcement is going to look like with unregulated operators. So the concern has not necessarily been the people who we're permitting, but people who are delivering into our city who are not permitted. So that's been a space in which we've devoted or started to bring together a code enforcement team so we can work through a multi-pronged strategy to really make sure that our operators who are playing by the rules have the benefits of the marketplace.
So Eugene, isn't San Francisco a city and county as well?
That's correct.
And so is Denver. And, you know, Marley's sweet to say how we really had this great collaborative process. Well, we're lucky because we are a city and a county.
For sure.
And then we have our mayor, as you saw, you know, being really clear that once this passed, we were going to do it and we were going to get it right. And so we had a lot of that help, Marley and I did, in kind of bringing all those different agencies to the table. And Eugene, I do want to ask a little more about delivery. But
of course.
well, I guess one thing, are you applying your equity program to these new delivery applications, and how are you doing that?
Right. So there are two ways that you can currently operate a cannabis business in the city and county of San Francisco, right? So either you had a business before the legislation was passed, either you had a medical cannabis dispensary that was governed by our Department of Public Health, in which you were regulated, they knew about you, you had a permit, right? Or you were a part of the existing supply chain to those businesses. And there was an amnesty period in which all of those operators had to come forward, essentially comply with some low-level compliance, right, to make sure that your building wouldn't explode, right? So all the city inspectors went into those spaces and made sure that they were viable. If they were, then you got a temporary permit. So existing businesses, we essentially transitioned. For all new businesses, they had to come through our equity program. So that includes all activity types, cultivation, manufacturing, distribution, retail, delivery, you name it, testing laboratories, the whole supply chain.
Good, good. And we can talk about that in more depth soon. Marley, so what's on the horizon for Denver?
I'm sure Dominique is painfully aware how busy this year was in our state legislature. But so we're working with the MED. I think many of us sit on the working groups to try to figure out rulemaking. But and this has probably been talked about through this conference. But there was a delivery bill that went through, a hospitality bill, and which would create basically a social lounge, and also a social lounge where a small amount of sales could occur. And then some sunsetting types of things, including an accelerator license. We are also working on looking at implementing a license type that actually was passed last year, I believe, which was a research and development license type. So there's a lot going on in the state and in the city right now. I would have to say that, I mean, one of the heavy lifts that Ashley's team has had to do is figure out which one do we do first. You know, that's a big question and a big lift. But part of that, building into it, is, okay, we have all these new license types coming on board. How are we going to implement our equity work that we've been working on into those new license types? And so that piece is an ongoing discussion. I think Bia touched on it really well on her panel yesterday. All of these, though, I think my approach to it, my team's approach, has always been from a public safety, public health lens. I like Dominique's phrase of a risk-based approach. I think that's really is our guiding light. I know the Cole memo is no longer, but those federal priorities that were in the Cole memo still remain something that we take seriously in crafting our policy. I think Ashley would probably agree with me on that. I don't mean to speak for her. So those are the things we're wrestling with right now. We're still in the rule-making process with the MED, and I'll let Dominique touch on that more. But that's how those are our concerns. We always have a public safety, health concern, diversion concerns about any of these things. And then the big thing for us also, in addition to that, is the hemp. How are we going to implement some kind of a hemp program in Denver? Right now, we have 2 ordinances that basically outlaw hemp in Denver. It sweeps marijuana and hemp into the same thing. We have a 36 plant ordinance so that you can only have no more than 36 plants, whether it's hemp or marijuana, in any zone lot in the city, which pretty much restricts everything. This is outside of a licensed facility. We also have an ordinance that prohibits solvent-based extractions outside of a licensed facility, so nobody's able to extract from hemp unless they're doing it in a licensed marijuana facility, which isn't allowed. So it's pretty much unlawful to do any of these things in Denver. So that's something we're going to have to be wrestling with over the next year or two to figure out what that's going to look like.
And maybe I should have started with Dominique, because the way our process works is all of these new licenses will first go through state rulemaking before it gets to the city. So Dominique, do you want to explain how you guys are moving through that, and then also what you're thinking about for race and social equity?
Sure. So starting with delivery, we are preparing to issue licenses beginning in January for home delivery. So the first year will allow for home delivery of only medical marijuana from a medical marijuana store. The following year will open it up to allow for what we call transporters, those who under prior law were permitted to transport marijuana only from business to business, but will now allow for those transporters to deliver both medical and adult use marijuana to private residents. So that following year, it'll open it up to both medical and adult use marijuana, as well as retail or adult use marijuana stores to conduct the same activities. Social consumption is another focus, as Marley mentioned. We are implementing the hospitality bill, as it's called, that allows for the issuance of 2 different license types. One is a bring your own model, and the other allows for limited quantity sales on the premises. For the bring your own model, that license is allowed to be a mobile license, so think the party bus scenario. Things that we've had to contemplate around our rulemaking process and implementation of this bill have been allowances for a retail food establishment to operate a hospitality license in an isolated portion of the premises. So we need to really define or identify what that means exactly, as well as allowances for things like patios, rooftops, yoga studios, different concepts that we should be thinking about, and this goes to the need to ensure we are collaborating with stakeholders so we can understand what they may be contemplating and inform what we can address more expressly in rule, and what other resources we can build out following that rulemaking session through compliance tips, industry bulletins to ensure we are communicating following that rulemaking process. We are also working on, and we've done our initial set of emergency rulemaking on an investment bill. Under prior law, we approved every owner, no matter the percentage of a marijuana business, was subject to investigation and approval. This investment bill has streamlined that process. It's a significant shift from our prior framework, but the focus is on those who control the business. So we're looking at those with a 10% or more percentage ownership in marijuana businesses, or who actually control the essential functions of that business. And those entities or individuals are subject to that approval process. Those who don't have control and who are under that percentage threshold are considered passive beneficial owners. And so then that provides more flexibility for businesses, and that includes exemptions from disclosure or pre-approval. It also opens the door to public investment. Prior law expressly prohibited publicly traded company ownership in marijuana businesses, so this is another big shift for us and something that we've been navigating, where this legislation identifies certain types of publicly traded companies that can participate in ownership of marijuana businesses. We also have our accelerator program that we're implementing based on this last legislative session, which would allow, so it's limited to just manufacturing operations and cultivations. So where we have an existing manufacturing facility or cultivation that has an interest in essentially hosting a new business, hosting somebody to provide support. It can be capital and other types of support to that smaller operator. We are working through what the components of that program should look like, what sort of things we should be taking into account when you have two operators on one premises, and ensuring we can support this program in a way that's intended by the General Assembly and essentially support successful operation of both that host licensee and the accelerator new business licensee.
So Dominique, do you think it's accurate to state that this is probably some of the biggest changes in our marijuana law since legalization? I think so.
Yes,
Yeah.
absolutely,
Yeah.
I would say so.
Yeah, yeah. So busy
Yes, very
time,
busy.
busy time. So Brandon, what is new in Portland, and how are you going to prioritize what you have to do, and how are you going to get it all done?
Yeah, well, in Portland, we're fortunate that we have both delivery and DiGiorno. So,
Yeah.
sorry, that was I even wrote that down here, and I thought it was funny, and it's just not.
Yeah.
But we already have delivery in Portland. The equity work that we began last year will continue and strengthen. And I talked about it at the social equity panel yesterday. But our public involvement, a public advisory body whose explicit charge is to recommend equitable outcomes in cannabis policy. They're getting ready to give their first round of recommendations. So that's exciting. We've implemented some license fee credits, some discounts for equity applicants, and we're waiting on the completion of an independent market study so that we can get a better sense of what Portland's cannabis marketplace will look like in the next few years, so that we may be able to better target those benefits. And also through facilitating our restorative justice competitive grants process. So all of that equity work, and my recommendation to all of you who are just getting started with these regulatory frameworks is to do that work early. And a lesson learned for Portland is that we wish we would have incorporated some of these equity frameworks much earlier on than we did. So that's coming and will strengthen. Social consumption keeps going to the Oregon legislature. It keeps not passing. But the things I think about there are how much staff time for the city will it take once those are up and running? Will the city choose to have certain distancing requirements or odor mitigation requirements? Will it be indoor or outdoor vaping or edibles? You have the Oregon Indoor Clean Air Act that doesn't allow for vaping. So all of those considerations. And then finally, the data and the technological capacity aspect of the work that we do, I'm not sure that Portland fully understood the amount of the need for good data collection, the need for strong, modern technological systems that can communicate at least with other city bureaus and offices, and ideally with the state. So all of that is on the horizon and very exciting.
So Brandon, you've been doing this for a while. And also now as you're looking at your equity applicants and your equity program, what's your philosophy on enforcement? And I know there's been some conversation about, now you in Colorado, we've been doing this so long, in San Francisco as well. We definitely felt like we needed that high level of focus initially with the Cole Memorandum. Are you still in that sort of posture, or have you pivoted at all?
Well, yeah, I mean, there is an enforcement aspect of our program. We have inspectors, annual inspections. And our focus in that is really to be as collaborative as possible. It doesn't mean that you're not firm. It doesn't mean that you don't uphold your requirements. What it does mean is that there's a high level of communication within our office. We have a hotline that is staffed with actual people. We try to get back to people by email or by phone within hours. We try to be extremely responsive. And Eugene mentioned this earlier, that philosophy comes with a staff cost. But we think it's important because our view is, yes, there is enforcement, but we want to welcome in business owners so that they may be regulated, that they may be taxed, that we may track the cannabis, that we can ensure that it's safe. And so for myself as a public servant, I have an obligation to try to help people meet that bar of regulation. So that's how we approach it. Most of our enforcement energy is focused on unregulated businesses. We had a case where we had a fully unregulated retailer across the street from a licensed and regulated retailer. If I were that licensed and regulated business, I would think it was pretty unfair that I paid the fees, I went through the hoops, I did all that work, and now who is protecting me from this other business that didn't do those things? So we were able to do something about that. And then the other high focus would be butane extraction. That's where we have the strictest permitting requirements. That carries the greatest level of risk, particularly in an urban environment. And one thing where I wish we had a little more capacity was with unregulated butane extraction. I'm thinking about if you go to Craigslist, the Portland Craigslist, you can see advertisements for people selling butane hash oil. What I wish our office had was some sort of capacity to connect those advertisements with a particular physical address, but that's not something that our administrative staff have access to. But that would be something that would be well welcomed.
So Eugene, Brandon referred a little bit to you in San Francisco's enforcement approach. Do you want to expand on that a bit for us?
Sure. One of the things, so I mentioned that we're in the process of developing a code enforcement group to make sure that we have a collective understanding about our approach. What that has been so far is mostly education, right? Primarily because our operators have taken steps to demonstrate that they want to come into compliance into the regulated marketplace. And we want to make sure that we're offering them some guidance in spaces in which they're not meeting our standards and communicate very clearly to them what our expectations are. Mm-hmm. So that's been our priority so far as an education approach compared to enforcement or strict enforcement. One of the things or the ways that we've been fortunate is that the state has really taken a leadership role in that regard. And so if there is an unlicensed operator who is operating in San Francisco, they can communicate that information to us. In the case of unlicensed delivery operators, it's really challenging because oftentimes we don't have a physical address. Mm-hmm. And so we're starting to figure out what is going to be our strategy for really engaging those operators. Fortunately, we don't have some of the issues with some of our peer jurisdictions who have actual unlicensed retail operators. Mm-hmm. As I mentioned, most of our challenges have really been on the delivery side. Yeah. And so we're really building out that capacity now to figure out what is going to be our approach kind of in Cannabis 3.0. One of the things that has been really important to us in this most recent round of legislation is providing our office with more flexibility in enforcement. So in thinking about the existing ordinance, it's really 0 to 100. Either you're in compliance, right, or you're not in compliance and the stick is very severe. And so what we want to do is create more flexibility, whether it's a notice of violation that gives people more time to come into compliance, a staircase system in which we issue kind of consistently ramping up a series of violations. And so that's something that wasn't present in our ordinance, but we had to include to make sure that people who were at least trying to come into compliance, we didn't push them back into the unregulated market.
Right, and that's an interesting point that you make, because I hear different people, including us in Denver and people on our team, talk about, is there or isn't there really something called the gray market? Aren't you legal or you're not legal? And if you're legal, you're legal, and if you're not, you're a black market and you're illegal. Marley, do you want to touch on that? Do you feel like our philosophy on enforcement has shifted, or what are your thoughts?
I think just focusing on the regulated side of this, we still have the black market, flat-out black market that we still enforce, so I'll just leave that to the side for a minute. I would say our approach to regulation and enforcement has evolved as the industry has evolved. You think about our history. In 1999 is when Amendment 20 passed, and that was our medical marijuana amendment to our Constitution. Then for another decade, there was no regulation at all, and so it was kind of the wild, wild west, and things just popped up. So once we finally started to regulate this industry, both on the medical side and the retail side, we were trying to rein some things in that had gotten out of control during that decade. I don't do that. If I'm going to give you a recommendation, don't do it that way, because it's harder to rein it in, and they're not used to being regulated. So back in the day, in 2014, when we started to try to really implement enforcement and regulation, the immediate reaction was to file a lawsuit against the city. Do a regulation, file a lawsuit. And that was kind of the pattern that we had going for a while. It isn't that way anymore, and it's more, as I think Brandon, his points were really great, that it's way more collaborative, not all the time. I mean, we have to be firm and we have to say we mean it when we have these rules in place, but it's a lot more collaborative. I can count on the fingers of one hand the lawsuits that we have going rather than having to use both hands. So we've come a long way. I think it's an evolving thing for the city and how we look at it and how we've been able to approach it, but also on the industry side as they get used to being regulated. I would say that our evolution for Denver specifically, we played a lot of standing in the gap role at the beginning, where there was just no state law or federal law that applied. And so we created law to try to put our fingers in the dike and get our hands around some public safety, public health issues that were happening, like BHO explosions or massive warehouses full of plants that were just flying under the radar, or the pesticide issue that I'm sure you've heard about ad nauseum this week in 2015 that just caught us out of the blue. We didn't know anything about pesticide law. So we've kind of gone through all of those learning bumps and hurdles, and we're to the point that Brandon's describing, where we can actually take a deeper look at, are we doing this right? Is there a better way we can be doing this? And it's kind of a refreshing phase to be in, frankly.
Yeah. And I think, Dominique, with the MED and with under Jim Burak's leadership, you guys are really looking at, as I understand, empowering businesses, looking at it kind of more in that light than enforcement. Can you expand on that a bit?
Well, and we do have an enforcement function that is an important component of our operations, but what we can say is that the success of those businesses we operate speaks to our success as well, and that's the lens through which we are looking at this and approaching issues. So we have, over time, I would say we have had an enforcement-focused approach, and it also does include a progressive approach and what we have called a progressive discipline approach. But when I hear progressive discipline, that also touches on enforcement. And with Jim Burak, who I think is here under his leadership, has been helping us enhance other ways that we can look at how we resolve issues that that we encounter, and acknowledging that we shouldn't limit ourselves in our agency to one type of intervention strategy. There are a number of other tools that we should have available and that we've developed over time that speak to going beyond just a reactive approach. So if we're looking at outreach efforts, education resources that we can develop and that we can develop more collaboratively rather than things that we've developed on our own and then just issued independently, when we can approach things this way, we are, I think, hitting more on the public health and safety focus that is so important to everybody engaged in our framework, in a way that we are getting ahead of issues. We are working closely with licensees to support their compliant, successful operations, rather than approaching things in a way that is ultimately reactive, and where an issue has already occurred to the point of needing to take some disciplinary or enforcement action.
So, as we said, this panel is about evolving and changing and the new innovations coming on, and we've talked about how you handled it in the past. We talked about the new things coming up. We've talked about how your enforcement models have evolved. We have about 30 more minutes, so we'll open it up to questions. But before we do that, any advice, any final words that you all would like to give this room of regulators? And why don't we start with Brandon?
Yeah, there's a lot I could say, but the four things that came to mind were the first, the equity frameworks. As I said earlier, please do consider those early, because once that marketplace is saturated and baked in, it won't be reflective of the marketplace that you might intend. And by the way, all of that work, the work when we talk about equity, we talk about equitable outcomes. To me, it's an acknowledgement that there have been disproportionate impacts and outcomes, particularly with communities of color because of cannabis prohibition, and that as government, we have an obligation to do something about that if we can. So that's one, is to set that stuff up early if you can. The second is to go slow, again, if you're able to. I wish that Portland had had more time. From September of 2015 until December 1, 2015, we were expected to create all the forms, all of the websites, to figure out who's going to get to apply first, to work with the auditor's office, the city attorney's office, and all of this stuff had to happen so quickly. If you can give yourself more time, if you can convince your elected leaders to give you more time, definitely do that. The third is just to be human in this work. You will make mistakes. You will be wrong sometimes. That is okay, because you're human. And the last is just to be tenacious. Be tenacious in the questions that you ask, the phone calls that you make, in your community involvement, the development of those rules, and the stress testing of those rules. Be tenacious in your creativity when you're developing these policies, because there is a universe of different outcomes that you may not foresee. Have many thought partners, ask a lot of questions. That's going to be super, super helpful.
Great. Marley?
I'm not going to let Brandon go first anymore. He steals my stuff. Although baked in was funnier than DiGiorno. That was good. So I kid, but it's true. My points are exactly what Brandon said. There's a phrase that we say all the time on our team, is right, not fast. Yeah, it would be nice if you had time, as Brandon's saying, between the creation of your program, whatever it might be, either a voter initiative or a statutory change, to have the time to put it in place, absolutely. But you're going to be rotating and pivoting, as we've talked about this whole hour. So when you're doing that part, think about right, not fast. Don't put something in place because it's the easy thing to do. Make sure you're getting it right. You're taking into account all of the public safety, public health concerns before you implement something. I know this keeps getting said, but I mean it. It's the only thing that helped Denver be successful in this. Collaborate as much as you possibly can. I know we're lucky in the city and county of Denver that all of our agencies are working together. I think a lot of that, and I've heard that from you, is that we had, and I'm not tooting Ashley's horn just because she's standing there, but under her leadership, and she was housed in the mayor's office, so she brought the authority of the mayor to the table to kind of force that collaboration. So that was baked in from the very beginning of our process, and it was critical to our success. So if you can build some kind of a collaborative model, even if you can only get a couple agencies involved, do it. It's going to help you be successful. And the third thing I'm going to say, and I know we've said this throughout also, don't be afraid to learn from the industry. I know there's law enforcement in the room, and that goes against your grain, but there's a lot they can teach you. I have learned a lot from what they do. I've gone on so many field trips, I can't tell you. I learn from what they're doing, what they tell me, from what they experience, so don't be afraid to do that.
Okay.
Eugene?
Sure. So a lot of this is going to sound similar, but I'm going to say it anyway. One of the things that I mentioned before is engaging with stakeholders, right, pretty often is really critical. Creating additional flexibility in which you have the space to do so, right, is something that you'll appreciate when you're in the process of developing policy. The commitment to an iterative process, right, communicating that clearly to everyone who's involved to make sure that everyone knows we're not going to knock it out of the park on the first instance, right? So managing those expectations is really, really important. And I think another thing is now we're really fortunate to have the benefit to have other jurisdictions who have gone before us to figure out some of the issues, right? So in spaces in which you have the opportunity to ask additional questions, to leverage the expertise of other jurisdictions, certainly you want to take advantage of that opportunity. One of the things that was really, really beneficial in the first year of legalization is that we had the opportunity to have those conversations with the leadership in Oakland, in Sacramento, and in LA, because we were all facing similar challenges. And so it was really helpful to be able to get on the phone and hash out a particular issue, whether it was over enforcement or how they were dealing with management agreements or operating agreements. And having those kind of relationships ended up paying off. The last thing that I'll mention is that it was really important for us to develop really strong relationships with some of our stakeholders internally, both policymakers, right, so board of supervisors and other politicians, but also with other departments, right? So we did have the benefit of being both a city and a county, but we meet every week with our digital services team for 3 hours. Every week we meet with our city attorney. Every week we meet with the Department of Public Health. Right, every week we meet with the controller's office. So we have a situation in which we're really working together to figure out what is the best kind of framework that we can provide. And when questions come up, we know that we can rely not only on the staff in the Office of Cannabis, but also our city partners.
And do people complain about your meetings like Marley just did?
I mean, I'm probably the worst at it because I roll my eyes actually in the meetings, but I do recognize the benefit for sure.
Well, Dominique, what about a different question, since maybe yours tracks their answers? What can you tell us what you're most proud of after all this work that you've done for these many years and the great successes you've seen?
Yeah, so this, I think, speaks to both advice that we could provide to other jurisdictions, as well as something that we have done and are proud of. We think has been really, it has helped us take our agency to the next level, essentially, is making sure we are bringing the right skills, experience, the right expertise into our agency. And that includes, and so where we started with an enforcement, general enforcement approach, I think that resulted in it's, and again, this is a critical function, is law enforcement personnel. We have criminal investigators and compliance investigators on our staff. That is a critical function. We also have other critical functions that we need to think about, and that can be informed by thinking through what what you're implementing in your program, and where, with a lack of federal oversight or approval, where are there components of your program where the federal government would otherwise have a role? That includes, for us, the FDA, SEC, Department of Ag, and how can that inform the different skill sets that you could bring into your agency? Individuals with scientific backgrounds, data analysis background, legal background and experience, financial examiners. That has been one very important way that our agency has evolved over time and we've seen brought a ton of value.
Wow, great tip. Eugene?
Yeah, very quickly. One of the things that's really important, if you can do it, right? Not you can't do it all the time, but if you can craft regulations with an eye towards implementation, you're not always going to be able to anticipate what significant issues are going to be in the future. But if you do that, right, really thinking about, well, what can go wrong if we do this or try this approach? Sometimes you can anticipate problems before they become catastrophes.
Great. All right, we've got sort of 25 minutes. Any questions for this great panel?
Hello, Craig Small with Hope and Law Group. I've worked closely with the MED, worked closely with Denver, and I've actually worked closely with Oregon as well. And that brings me to the question I want to ask is there any proactive measures between the states to look at each other's regulations? And other than public health and safety, finding things that work in other states and say, that's a good idea, let's bring it to ourselves. The example I can think of is Oregon has their label pre-approval process. And I think Colorado would really benefit from that. Excuse me. Certainly clients don't want to hear me say this, but we spend a lot of time reviewing labels on a nationwide level, and every state has their different set. So for Oregon, it's easy. We just kind of do what pre-approval we can and then send it to you guys. But for the MED, it'd be nice to have.
So we have thought about that. When we were developing our packaging and labeling regulations, we worked closely initially with Washington and Oregon in looking at their model, and that's what informed our development to an intended use model. We also learned about the pre-approval process for packaging and said that it's something we should have done. Probably. But when we're at a point of knowing that there's packaging is on the shelves and have, I think, run into some challenges around what rolling something like that out could look like in a way that we are ensuring we're not creating disruption in the industry as well. So it is something we've acknowledged as a smart move, and where we've looked at other state programs to inform how we've developed our regulations, and will continue to do so. That is something we kept in mind. So if you have any ideas in a way that we won't get sued for that approach, let us know.
Anyone else with that response?
Just a lowly city employee, so.
Yeah.
All right, over here on your left.
Oh, okay.
On your right.
Right, okay.
Hi, everyone. I'm Sophie Quinton. I'm a reporter for a news outlet called Stateline. I write about cannabis issues as well as a lot of other things. I have a question about kind of a live issue in the news right now, which is this outbreak of vaping-related illnesses. And I'm wondering to what extent you're seeing that in your jurisdictions as a regulatory issue, i.e. these are products that, you know, have been approved, they're legal, and yet they're making people sick, or rather it seems more like a law enforcement issue in that, you know, these illnesses might be connected to, you know, unregulated or illegal products.
Who would like to start with that one?
Well, I can say from the city side, we don't do testing of cannabis. I know that this is on Governor Kate Brown's radar, and the Oregon Health Authority has issued a notice about it. As a city and as a regulatory framework that really has been regulating the buildings in which the processing of cannabis takes place rather than the product itself, I think that our most helpful role is to amplify any messaging that comes out of that research, that data collection, and all the work that's being done at the state level. And so we will amplify that message out, but that's about as thorough of an answer as I can give.
Yeah, and the state of California has been pretty proactive. We also worked with the Department of Public Health in San Francisco pretty early, when I think it may have been the third or fourth case, to actually think about what was happening. How do we craft an approach to figure out what information we need to convey to the general public? And so one of the things that they did is they took it more from an approach in which they had protocols in place to figure out how to communicate information, both to practitioners and also to the general public. And one of the things that we did is on our website link both to the Department of Public Health's campaign and then also the state's campaign emphasizing the need to purchase safe and regulated product.
Great. Dominique? Sure.
We have worked very closely with the Department of Public Health and Environment as we continue to navigate issues around vaping-related illnesses. And this issue has come up as in our rulemaking working groups, where we are soliciting feedback from stakeholders around our testing program. We have a robust testing program, but where we can solicit recommendations from stakeholders from the Department of Public Health and Environment, from public health officials. That is, we've seen that as a critical opportunity for us, a forum for us to see where we can develop our regulations in a way that is responsive to some of the issues that we've identified. Also looking at labeling requirements, there are discussions around how we can continue to expand on that to ensure that that additives are included in ingredient labeling requirements. That was a discussion that was raised, or an issue that was raised specifically by stakeholders that is informing our current drafting of proposed regulations. So it is an active discussion that is ongoing currently.
And I would say our Denver Department of Public Health and Environment is one of our agency partners and has worked with the Office of Marijuana Policy to message out. We do regular industry bulletins. So there have been some instances with additives causing problems and that kind of thing. And we work with the Office of Marijuana Policy to get that message out. But that's really all I have to add to that one.
Thank you.
Hey, Dominique, quick question. When you gave your last advice about like hiring experts to build up your agencies, how many people does the MED currently have? And I assume they are paid with marijuana tax dollars. Do you know like more or less what's the percentage of those marijuana taxes that go to personnel?
Oof, now you're asking me the tough questions. We have approximately 104 staff within the MED, the Marijuana Enforcement Division, across the state. That includes our licensing folks, criminal investigators, compliance investigators. We have financial investigations unit, policy staff, and administrative staff. And our program is funded on licensing fees based on statute, so that it isn't specific to taxes, but to fees that are paid for applications that are submitted and licenses.
Do we have any more questions?
All right. Okay, great. Well, thank you so much for sharing your information and your expertise. Can we have a big round of applause for this wonderful panel? All right, everyone, thanks for being here. I've really enjoyed it. I've enjoyed getting to see everybody, and I hope you enjoyed it too. And please feel free to continue to reach out to us as you have questions and give us feedback on how you like the symposium. Oh, and Eric is saying, could you please fill out the yellow card that's on the table? And aren't we going to send out a survey as well, a more detailed survey? I think so. Okay, great. All right, well, thank you, everyone. We really enjoyed having you here.